Welcome to a special edition of Legal AF. We are honored and thrilled to have Judge J. Michael Luttig back with us, icon, lion of the Constitution, defender of the Constitution, and who has some strong opinions that we need to hear from, our audience needs to hear from, about Trump versus the United States and the immunity decision, the 6-3 majority of the Supreme Court, written and penned by Chief Justice Roberts, just issued. What does it mean when we talk about core presidential duties expressed in the Constitution for which a president, named Trump or otherwise, has absolute immunity? What are the contours of that? What is official duties that are given a presumption of immunity? And how would the prosecutors ever overcome the presumption to show that there's no danger of intrusion on the executive branch? And then what, in this case or in future cases, would constitute unofficial conduct, which is the part that's prosecutable under the ruling of the United States Supreme Court. However, they've also built in certain limitations and certain hurdles for the prosecution. They can never inquire as to the motive of the occupant of the White House at the time in any type of evidence or documents or testimony. And there's also evidential hurdles as well, where you can never put on now, based on this ruling, any evidence of official conduct to try to prove that what is outside the outer boundaries is unofficial conduct. So that is what we are now left with. And there's various scenarios that have been played out on social media, and even among our audience, Judge Luttig, about, well, does this mean, as posited in a way by the dissent led by Justice Sotomayor, that the SEAL Team 6 scenario, which gave pause to the DC Circuit Court, is possible? Could somebody who is the president or outgoing president of the United States, as commander-in-chief or otherwise, give a command for a drone strike against the other party or its leader? Could he sell pardons as part of his core constitutional power? What are the limits? I mean, they're not just thought experiments anymore. It's stuff that's keeping our audience up at night, and I can't think of anybody better to address it than Judge J. Michael Luttig. Judge, thanks for being back with us for this interview.
Thank you, Michael. It's always a pleasure. In fact, it's an honor always to be on with you and the Midas Touch Network.
So, Judge, let's kick it off. You have some good and strong opinions from your vantage point of being a constitutional scholar, a former federal appellate judge and defender of the Constitution, even from the Federalist wing of the party. What's your take on what Justice Roberts just cobbled together with a 6-3 majority, and what are its implications and ramifications moving forward?
Michael, the Supreme Court's decision in Trump against United States represents the unsouling of America. America's democracy and the rule of law are the heart and soul of America. It is our democracy and the rule of law that has made America the envy of the world and the beacon of freedom to the world for almost 250 years. The Supreme Court cut the heart and soul out of America with this abominable decision of constitutional interpretation, or should I say, so-called constitutional interpretation. The defining maxim, if you will, of America since its founding has been that in America, no man is above the law. That can never be said about America again after Monday's decision by the Supreme Court. Without any question whatsoever, the Supreme Court of the United States held in Trump versus United States, that the President of the United States, and in particular, the former President of the United States, Donald Trump, is above the law. This decision, within 2 days, if not sooner, was being compared to the most opprobrious, ignominious decisions in all of Supreme Court history, such as Dred Scott and Plessy against Ferguson and Korematsu against United States. I even tweeted that Sharon Davies, the president and CEO of the Kettering Foundation, I think one day after the decision, wrote that Trump against United States now takes its place alongside those worst decisions in Supreme Court history. I want to try to respond to the concerns that I know that your viewers have, and frankly, all Americans have about this decision. I wish I could allay those concerns, but I cannot. But the most important thing that I want to say today about the decision is this. The Supreme Court decided to give absolute immunity to Donald Trump, and then wrote the opinion to justify it. How do we know it? This is how we know it. Donald Trump has been charged with the gravest crimes possible against the United States of America. Those charges and those allegations were the only issue before this Supreme Court. That's all the court was required to decide. And by the way, for almost 250 years, that's the only issue that any Supreme Court in history would have decided. What did this Supreme Court do? It decided the issue of presidential immunity for all times, in all contexts, Michael, possible under the Constitution. It is the precise opposite of what any court of the United States, and especially the Supreme Court of the United States, ever does. Now, why do they do it? There's only one possible explanation. They had to decide that that Donald Trump had absolute immunity because he's alleged to have committed the gravest crimes against America. So if they were going to hold that he was immune, they had to adopt his argument that he was absolutely immune from even the gravest crimes that a president could commit against the United States of America. The court had no choice. If it were going to hold that Donald Trump was immune from prosecution for the grave offenses that he committed. This is a classic case where the Supreme Court decided what it wanted to decide and then went in search of the constitutional reasoning that would support that decision. Unfortunately for America, there was no constitutional reasoning. None based in the Constitution, the court's precedents, history, anything, anywhere to support that decision that they made before this argument ever took place.